Your Honour, if it pleases the Court, my name is Kathryn Richards and I appear for the defendant, Mr. Johnny Wishbone. With respect to the indictable charges brought against my client, I submit an application under Section 590AA of the Queensland Criminal Code to exclude evidence. Your Honour, the facts brought before the court by the prosecution are not in dispute. However, the substantive facts that provides grounds for the defence's application, I believe, should be canvassed for the record. My client is a Torres Strait Islander, born 29 June 2000 and is therefore currently aged only 16. My client was arrested at the scene of reported break and enters where he was placed into an unmarked police vehicle, questioned whilst driving around the suburbs, which is in the nature tended to you on page 2. During this period, the prosecution submits that my client made full admissions to 106 break and enters, which provides the grounds for the 106 indictable charges against my client. My client was then taken back to the police station where he was introduced to a lady, Donna, who was apparently a social worker. The constable then commenced my client's second interview. Your Honour, I submit 3 main issues with the process the prosecution underwent to obtain the only evidence supporting the Crown's 106 charges brought against my client. Firstly, the constable's failure to caution my client, as required in Section 431 of the Act, in addendum to not providing my client with the knowledge of his right to remain silent. The Act, if the Court pleases, is the Police Powers and Responsibilities Act, which I will now refer to as the Act. Secondly, treating my client as someone who is not Torres Strait Islander or a child. Therefore, Your Honour, my client refutes all 106 charges in surreptitiam on the above mentioned grounds, and I will present my argument accordingly. Prior to the commencement of any questioning, a police officer must caution the person required by the responsibilities regulations. On both interviews, Your Honour, my client was not given notice of his rights, nor was he given the opportunity to understand them pursuant to the Section 431 subsection 3 of the Act. Your Honour, it is a universal knowledge that the Aboriginal and Torres Strait Islander minority group are somewhat disadvantaged. This is acknowledged by the Act as it is evidenced by Section 420 that provides additional support for this group. Section 420 subsection 1A applies if a police officer reasonably suspects that a person is of same. Your Honour, from looking at my client, it is obvious that he is of Torres Strait Islander descent. Therefore, questioning should not have occurred until a legal aid representative was involved. It is not stated whether Donna is associated with legal aid. On any grounds, my client had previously been interviewed in the police vehicle. I would also like to state for the record that the initial questioning of my client in the police vehicle is a clear example of gratuitous concurrence, which is stated in the Supreme Court of Queensland's Equal Treatment Bench Book 2005. And I will quote, "It is a tendency of a speaker to agree with a proposition put to him or her regardless of whether the speaker truly agrees with it or even truly understands it. This produces illogical and misleading evidence, particularly where there is a perceived imbalance of power, as evident in the situation where an officer who is non-Aboriginal or Torres Strait Islander is in a place of authority over someone who is. It is well known duty that the police officer is obligated to understand cultural differences and question the relevant person accordingly. The police officer in this matter has failed that. Furthermore, my client is only 16 years old and therefore should have been treated as such. Your Honour, Section 421 of the Act applies if an officer reasonably suspects that the person in question is a child. I will agree that my client is borderline. However, in that regard, the officer simply should have asked the question of his age. On these grounds, my client should not have been questioned without the opportunity to speak with a support person of his choice. This is therefore another breach of the Act. Your Honour, I would like it also to be noted that there have been other breaches. However, as time does not permit and it is evident that the evidence the Crown's charges are based on have been obtained illegally or unlawfully, I do not feel the necessity to elaborate on those additional breaches. Your Honour, I ask that at this time you employ your inherent discretionary power to exclude the omissions by my client. It is evident that the prosecution is relying on evidence of my client's omissions which have been illegally or at least improperly obtained. It is the public policy that protects evidence that is obtained this way from being admitted. Therefore, in the matter before you, admitting this evidence would be an abuse of process, or the collection of this evidence is an abuse of process. This very principle is held out by the High Court of Australia judgment in Ireland v Cross, where medical evidence which was obtained unlawfully was excluded. This idea has been further elaborated in Bunny and Cross, where expressing the need for public policy discretion in circumstances where there is, and I quote, a calculated disregard of the law by those who enforce it. Your Honour, this case is a clear example of officers who enforce the law not respecting the law. Therefore, if you were to admit evidence entirely and singularly that holds up the prosecution's case, I put to the court, should my client be convicted, would that conviction obtained by the aid of unlawful evidence be obtained at too high a price? Your Honour, I rest my case.